Good morning. My name is Alexander, and I'm joined by my colleague Shivaji Shiva. We're both members of the charities team at BWV. Shivaji and I have we're obviously planning to speak for around 45 minutes. And Tamar, if we could have the next slide, please. I'm going to start off by talking about the Charities Act 2022. And then I'm going to hand over to Shivaji, who's going to talk a bit about challenges for the charity sector and also some themes that we've identified within Charity Commission regulation. And as Tamar mentioned, please, if you have questions, please do put them into the relevant box, and we're aiming to leave some time at the end to try to deal with those. So without further ado, I'm going to talk to you about the Charities Act 2022. Next slide, please, Tamar. So many of you will be aware that this new act received royal assent back in February. In terms of its origins, it really reflects some work done by the Law Commission a few years ago when they produced a report called Technical Issues in Charity Law, which is the kind of title that excites charity lawyers, but perhaps not other people. But it was really a really wide-ranging investigation, report on a range of issues faced by charities. We were fortunate enough as a charities team actually to provide technical support to the Law Commission in relation to that. And the aim really was to try to introduce some deregulation, to simplify things for charities, to save them time and save them money. Now, not all of the Law Commission's recommendations have found their way into the Act, but many have. It's an act which, as I've said, is about deregulation. It's not about extending the Charity Commission's enforcement and other powers. It is about deregulation and simplification. And there are a range of changes. I suspect that not all will be relevant to all charities, but many will be relevant to many charities. And there are two particularly important changes I'd like to talk about in a little bit more detail. And those are in relation to, firstly, disposals of land, and the second in relation to the way in which charities can amend their governing documents, and in particular their charitable objectives. So I'll come on to those in a minute. But the one point I wanted to make about the Act is, although it's got royal assent, it's not yet in effect. And the reason for that is the Charity Commission have got quite a big job of work to do alongside DCMS in producing, I think it's around 20 new pieces of guidance which will sit alongside the new legislation. So the timetable for its actual introduction, the coming into effect of the relevant provisions, is staggered, starting in autumn this year, finishing in autumn 2023. So we'll see different parts of the legislation come into effect over that period of time. So let's look in a bit more detail about disposals of land. Tamar, if we could have the next slide, please. So this is an area that will come into effect. It's due to come into effect next spring. And I thought I'd just walk you back, if I may, to the origins of the existing provisions around disposals of land, which I suspect many of you will be well aware of. But perhaps if I just summarise the current position, which is essentially that if a charity wishes to dispose of a freehold interest in land or grant a lease which is for a period of longer than 7 years, the starting point is that the charity needs to obtain the consent of the Charity Commission before it can do that. Now, there are some exceptions to that consent requirement. There's a very specific one around charity-to-charity transfers, which are for less than market value and where the charities have compatible charitable objects. There's a more commonly used one, which I'm sure many of you will be aware of, which is a sort of what I call a whitewash procedure, which essentially enables the trustees of the charity to go off and commission a report from a qualified surveyor, so a member of the Royal Institute of Chartered Surveyors. And that report has to be prepared by the qualified surveyor in accordance with some regulations which sit under the current Charities Act 2011 and are quite specific in terms of what the qualified surveyor needs to report on. But it will include typically, obviously, the price, the market value, and also recommendations around whether advertisement is necessary, and if so, how that advertisement should take place. What the trustees then do with that report is take it away, consider it, And the decision that they have to come to is that the proposed disposal represents, I'm going to call it best value. Actually, the phrase in the Act is that the disposal represents the best terms reasonably obtainable to the charity. And the reason for that regime, really, I think, is just that at some point Parliament would have decided that property is valuable and that therefore there should be some fetter, some control on the ability of a charity's trustees to dispose of it. So, it's really all about trying to make sure that charities get best value for their property when they're selling it. So the new Act will make some changes, as I've said, from spring 2023. That fundamental principle about best value, that test of best terms reasonably obtainable, will still remain. But the process which the trustees can use will be slightly different. Firstly, the concept of the qualified surveyor will go and will be replaced by the concept of the, quote, designated advisor. Now, this will include qualified surveyors, but will also, that the pool will be larger. It will also include, for example, estate agents and agricultural valuers. And it can also include people who are employed by the charity or trustees of the charity who are appropriately qualified to prepare a report. The terms of the report itself will be simpler, and one key change is that there is no longer a requirement under the Act for, or there won't be a requirement under the Act for the report to advise in relation to advertisement. That will really be something that the relevant designated advisor can report on if they wish, but there's no requirement to do so. And then one other key change is that many of you will be aware, if you've gone through this process, that there are a lot of some confirmations that need to be included in the relevant transfer documents of the property, including a certificate signed by the trustees, which essentially confirms that the charity has gone through this whitewash procedure correctly. That's going to change slightly. The confirmation will be included also in any contract to sell a property, and also the certificate required from the trustees will no longer be required. So it will hopefully make the process of actually getting documents prepared and signed more straightforward. And the final thing I wanted to mention in this context is to do with what are called under the Act connected parties. So as the legislation stands at the moment, the whitewash procedure that I've described cannot be used where the disposal of property is to a connected party. So that would be to a trustee or an employee or someone who is related to a trustee. And it also includes any wholly owned trading subsidiary of the charity. One of the recommendations that the Law Commission made to the government was that this requirement for consent, therefore, from the Commission should not apply to, for example, a lease to a trading subsidiary. Unfortunately, that was rejected by the government, so it's not included in the Act. So if you're making a disposal of a property to a trading subsidiary, the consent of the Charity Commission is required if you can't get it into any other exception, which I think is very unlikely. But there is one change to the connected parties provisions, and that is that it will be possible for charities to grant a short term, by which I mean up to a year or a periodic tenancy of a year, leases to their employees for residential purposes. And this is probably only going to apply to quite a specific category of charity, but it could include, for example, educational charities where staff are required to live on site, care charities, again, where staff are required to live on site. And those will be accepted from the rules of requiring commission consent, and so one can use the different procedure. So I'm going to move on now to the other main change around disposal, around changes to governing documents. So next slide, please. So I described the aim behind these bits of provisions is really trying to harmonise some quite inconsistent regimes which relate to the way in which different charities are able to alter their charitable objects. Now, charitable objects are obviously fundamentally important to any charity because they essentially define what it can and can't do. And I think the Law Commission recognised in their original report that there are many reasons why charities will want to change their objects. It may be that the charity wishes to develop what it does in a different way, so that it starts to advance a different charitable object. It may be that the way in which the objects are phrased is really, really unhelpful in terms of the charity's ability to engage with its stakeholders and beneficiaries and perhaps grant funders. So a range of different reasons why a charity might want to change its objects. But the way in which that happens is currently very dependent on the way in which the charity is established. So at one extreme, you would have, for example, a charitable company, many charities being established as companies limited by guarantee. In order to change its objects, it would need to go to the Charity Commission. But the requirement around the Commission consent is pretty straightforward. Essentially, the Commission are asking the question is, is this a reasonable change? And I think in our experience, it's not often that one would receive any pushback from the Commission on a reasonable proposal to change a charity's objects. At the other extreme, you have larger trusts, where the only way in which to change the charity's objects is by obtaining what's called a see-praise scheme under the 2011 Act. So one has to go to the Commission and ask them to make a scheme, and there are only very specific reasons why they will make a scheme. It could be that the objects are it's no longer possible to advance them, or that the beneficiaries have been provided for in some other way, or that perhaps the objects have ceased to be suitable and effective. So it's a higher bar for those trusts. And so what the 2022 Act seeks to do is to make it a more consistent approach. So the consent of the Commission is still required, but they will apply a single test, which is whether or not the change to the objects that is proposed is, and the phrase is, suitable and effective in light of the social and economic circumstances. The Commission will also need to have some regard to the original objects, and so far as reasonably practical, a desire to keep the new objects similar to the old objects. But I'm certainly of the view that I think that this harmonised single test is likely to be much more straightforward for charities across the sector, albeit that it actually probably raises the bar a little higher for charitable companies while lowering the bar for charitable trusts. So it's important to bear in mind that even if you are trustee or executive of a corporate charity, so a company charity, you also need to think quite hard about how this might apply to the kind of assets you may hold on trusts, for example, endowment assets. It's likely to make dealing with endowment assets, that kind, more straightforward if you wish to make a change to its objects. Okay, so I'm going to move on now to talk a little bit more detail about some other areas. So if I could have the next slide, please. So there are some other changes. There are quite a few more, but these are, I think, the more important of the other changes. The first is that there is going to be a simplified procedure in relation to failed appeals. And by failed appeal, I mean the kind of appeal where a charity goes out and seeks donations, gifts from a wide range of people for a particular purpose, and for whatever reason that purpose fails, it can't be completed. The law here is exceptionally complex. That there are different ways in which that failure can take place. But really, all I want to say about the Act, is that the government have clearly taken on board the Law Commission's recommendations here, and are intending to try to ensure that where there is a failed appeal, charities do not have to get involved in the kind of very complex process that currently applies, which will often involve going back to donors to find out whether or not they want their money back. So, for example, there is now a de minimis sum of £120, where broadly there is no obligation to go back and find out what donors would like to happen to that money. So we will need to see, I think, how the Commission are looking to apply that. So we'll be looking to see the guidance that they produced this autumn. But it should assist charities in relation to failed appeals. The next area I wanted to talk about was authorization of ex gratia payments. Now, by ex gratia, I really mean a payment that a charity is considering making where there is no legal obligation to do so. It is purely a moral obligation which the trustees feel. I mean, examples of this could include a donor who leaves their entire estate to a charity by their will, leaving their own family without proper provision in circumstances where that family is unable to bring a claim against their estate. And in those circumstances, trustees may feel that morally there is an obligation to make a payment of some kind to the family. There is currently the ability for smaller ex gratia payments of up to £1,000 to be made without the consent of the Charity Commission, but any amount over that requires Commission consent. And the change under this Act really just reflects one of the recommendations of the the Law Commission, which is that there ought to be a sliding scale, and that's essentially what's been introduced. So there is a sliding scale of payments from 1,000 up to about 20,000, which will depend upon the level of income of the relevant charity. So if you have a charity with income of annual income of £1 million or more, then they can make an ex gratia payment of up to £20,000 without the consent of the Charity Commission. The power to pay trustees for goods and services. Many of you will be aware that actually there was a change made a number of years ago now to provide a statutory power for a charity to pay trustees for providing services. It's subject to a number of safeguards. It was always curious that the same approach could not be taken to trustees supplying goods, and no real obvious reason why there should be a difference in that treatment. Again, this was a recommendation by the Royal Commission, so that power now extends to both goods and services. Permanent endowment, of course, property which must be retained by a charity and can't be spent or applied. Sometimes we're talking here about a portfolio of investment assets. Sometimes we're talking about property that is used for the purposes of the charity. Often tricky to deal with in practice, and potentially difficult to deal with and make actually work for your charity effectively. There is an existing statutory power which enables the trustees of smaller charities with permanent endowment to release those permanent endowment restrictions. The current threshold is an annual financial limit of a value of 10k, and that's increasing to £25,000, just to give a bit more flexibility around that. But probably the key change here is that there is going to be a new statutory power for trustees to borrow from the permanent endowment. And what the Act is going to say, what the Act says, is that trustees can borrow up to 25% of the value of the permanent endowment if they think it's expedient to do so, provided that they repay it within a period of 20 years. But during that period, there is no interest payable. So in a sense, it could be a source of relatively low-cost finance for trustees if they wish to use part of the permanent endowment to support charitable activity elsewhere within the organisation. And then finally, just to mention a point in relation to legacies. Many of you will know that previous legislation introduced something called the Register of Mergers, and the aim was that when you put charities together by way of a merger, they didn't lose out on the possibility of receiving legacies under wills that might not take effect for a number of years. Unfortunately, there was a slight defect in the way that was drafted, which meant that actually legacies to a charity that had ceased to exist because of a merger wouldn't take effect if the terms of the legacy essentially required it to still be in existence. So that change has now been rectified under the Act, and will hopefully make sure that charities continue to be able to benefit from as many legacies as possible.
Good morning, everyone. So the context here is that we're seeing quite a number of boards trustees that we work with raise concerns about how they should respond to some of the challenges that we all know so well that are facing the charity sector at the moment. So in this second section of this morning's webinar, what I'd like to do is to run very quickly through some of the ways in which the legal and regulatory framework is worth bearing in mind in relation to those challenges. And in particular, to look at three different things. I think there are three broad themes about the way that the Charity Commission approaches its work in the sector. Two cases, the case of Butler Sloss and the SIF case, the Children's Investment Fund Foundation, and five developing areas in relation to the practice of the Commission, which emerged from some work that a colleague of ours in the charities team, Andrew Werrett, who spent a decade or so with the Charity Commission as a legal advisor, has done in reviewing inquiry reports and drawing from them some lessons. So those are the three things: 3 themes, 2 cases, and 5 developing areas. And the context for that, as I say, is this area of uncertainty. So for years now, lawyers and other advisors have been starting webinars like this by talking about the really challenging environment that trustees face and charity leaders face in coping with the uncertainty that they're having to navigate. And I don't need to labour the nature of that uncertainty, but just refer to the pandemic. The war's always with us, but now we're seeing it in Europe, and more recent issues such as fuel scarcity and the cost of living rises. All of these things are hitting organisations hard. And perhaps floating over the top of those challenges is a broader change, and the change referred to in the final bullet there, which is this idea that we're encountering a more polarized sort of debate, that there are some topics, be it race and what we do to secure a more equitable society, be it gender or climate change and the appropriate response and the pace of that response, which are making it harder for organizations to have clear debate because views are so strongly entrenched. And sometimes they get caught up in wider debates in society in that sort of highly charged and emotive way that has people talking about culture wars. So I'm not going to look at those in any great detail, as you might expect, and we'll try and focus on the regulatory issues that I've highlighted just before. So let's start with the Charity Commission. Could we have the next slide, please? And the starting point is change at the top at the Charity Commission with a new chair, Orlando Fraser QC. And as that might suspect, he's a very experienced Chancery barrister with some 28, I think, years in practice. And the big change there is a strong statement that he made at the recent Trustee Exchange conference just a few days ago now, where in his inaugural speech, he chose to focus on fairness, balance and independence as core values of the Commission. A focus that I think many trustees and charity leaders will have welcomed, and that many are hoping signals a positive change of tone. Next slide, please. So just to expand on that, the 3 things that I drew from having a look at the transcript of Orlando's speech, I heard it in person and was struck, like many people, by that positive change in tone. But looking back at it, it felt even better to just reflect again that he focused on the Commission being expert, an organisation whose judgment can be relied on by trustees as authoritative. And I think many of our clients find it challenging sometimes to pin the Commission down when they're seeking guidance and advice, and to feel that the Commission has the confidence to take a position, sometimes on difficult issues. So there's perhaps a hope that while it will always be difficult for the Commission to give broad guidance on complex issues which will apply differently to different sorts of charities, that there might be a greater confidence to take a stronger position and give an answer that might perhaps be more useful to boards seeking that support. And perhaps also when boards are seeking advice under the provisions of the Charities Act that enable them to seek advice, including, for example, Section 110, where they can seek advice from the Commission and be able to rely on that advice in making difficult decisions going forward. So, so there's that emphasis on an expert Commission, and then back to those 3 key values of fairness, balance, and independence. And here I think it's worth saying that, of course, many of the charities we deal with have had some concerns about the stance of the Commission and its independence in years past, in part because of some of the controversial statements made by Orlando's predecessors on the board. And in that, I think there's a willingness now to be reassured by the fact that we're talking about a man who has considerable experience with charities, going back as far as setting up a charity in the 1990s in relation to the conflict in Bosnia, as well as that legal experience and the avowed change in tone, and also 5 years experience on the board of the Commission. So let's hope that we're going to see that. And finally, I think focusing on just an extract from his speech in which he said that rather than criticise an otherwise successful charity excessively for particular honest and reasonable mistakes, that he's hoping to, he's keen to see the Commission focus on supporting trustees in getting it right when things don't go exactly to plan, as they often don't. And I think it's certainly the case that many of clients that I deal with feel that they would welcome that support, that acknowledgement that making mistakes is inevitable, and that they'd want to be able to look to the regulator in its role, to the Commission in its role as support, to provide the advice and guidance they need to move forward. So that's a bit about the tone. And on to the next slide, please. So the next broad theme is just about governance and control. So this is the control of the board over the organisation. You'll all have heard many times the emphasis that the charity trustees are ultimately responsible for their organisations and need, therefore, to be to have an overview of everything the charity does. And an emerging theme in Commission compliance work is its expectation that trustees should be in control. And I think there's a concern, given the controversy and the perhaps polarised debate that we're seeing, that the combination of that debate, of the public attention to charities and this desire for control, could make it very hard for trustees to demonstrate that they have fulfilled what's required of them when they get caught up in a wider societal debate. But what does this all mean in practice? Well, you know, what have we seen in the actual inquiry reports? Well, here we can have a look at one example that might help, the inquiry into Humanity Torbay, where the social media account bearing the charity's name was an account which belonged to a member of staff, as is not unusual. But when challenged, the trustees couldn't remove all the posts the Commission had asked them to remove. And so there's a lesson there in ensuring that the charity actually has the means to control the use of all the different sorts of media established in its name, and to be able to ensure no one is misrepresenting themselves and presenting themselves as speaking on behalf of the charity when they are not doing so. This comes up a lot in internal disputes, where it may be the case that someone is actively seeking to misrepresent the charity, but also in situations where there are perhaps community-based volunteers or others who have a role within the charity, but might see that role being emphasized or being misunderstood by others because they happen to be adroit at using social media and attracting attention in the name of the charity, and perhaps willing to say things that are more controversial and therefore more attention grabbing than will be said over the charity's official accounts. So there's a direct practical piece there about controlling the name and perhaps social media accounts and perhaps wider intellectual property of the charity. It wouldn't be a charity's webinar without also referring to some policies and about the need to ensure there are appropriate policies on how social media should be used and on how other assets, including intellectual property of the charity, should be used. There's also a piece that's about ensuring that particularly senior staff and trustees are clear about what they can and can't say in the name of the charity, even on their own personal accounts. It's not unusual for individuals to have accounts from which they may, that they're in their own name and that are for personal use, but from which they may make announcements about the work of the charity. And where that is the case, if the Charity Commission gets involved in regulatory activity, it's likely to seek evidence that the trustees have sought to monitor the accounts and to ensure they have overall control of the tone and nature of conversation on those accounts. So that's governance and control. Next slide, please. So moving on from the complexity of trying to manage the public face of the charity, another aspect of that is navigating controversy and ensuring that you can demonstrate clearly that everything that the charity does is in service of its objects. And I wanted to refer to this in part just to emphasize the challenge that we see in the polarization of debate. And very briefly, because many of you will be familiar with this, the National Trust inquiry report or regulatory report was a good example of this. And this was, as many of you will know, the situation where the National Trust produced an interim report on the connections between colonialism and properties now in the care of the National Trust, including links with historic slavery. There were complaints from a variety of quarters, including a number of MPs, and very soon the Charity Commission was drawn into having a look at the way in which that report had come to be made. The Commission's press release on its intervention described the report as having led to, quotes, public criticism. And the apparent breadth of that statement perhaps gives a sense of the problem, which is that criticism from just some quarters can come to seem as though it represents absolutely everyone. And of course, in addressing the issue, where did the Commission start? It started with the objects and looking at whether the charity was in fact operating to pursue its objects and whether the trustees had made sure that was the case. And they were particularly careful to ensure that trustees were not solely being guided by their own particular background, worldview, or political inclinations and interests, but by the objects of the charity and what would be in the best interest of the charity, those purposes, and the people served by the charity. So it all starts and ends with the objects. And that's often going to be a way of navigating those strongly held views and the resulting divisions, particularly where careful record is kept of the process by which decisions are made. National Trust was able to point to, I believe, a consultation of many of its members, as well as the involvement of a variety of well-qualified academics and others in satisfying the Commission that it had acted appropriately. So, and the concern here, of course, is that there is a risk that boards will be facing, which is that if there is that sort of division, that a lot of attention being paid to something that your board has done in its effort to do the best in a difficult situation without any particular concern to a cultural war issue and a motive issue will nonetheless come under attack from one or other party in one of those disputes and result in significant public relations criticism and a PR risk. On that, in fact, there's a statement from Orlando Fraser from before his appointment in his evidence to the pre-appointment committee, which is very positive. He said, sometimes you have to stick up for them, that is trustees, in the public eye if they're coming under media attack and so forth. All we would ever do is look at the facts and decide the position in accordance with charity law, full stop. Now that messaging feels more supportive than some of the current warnings on the Commission's blog about the views and sensibilities of the public beyond the charity's own stakeholders. It's about this we need to consider all of those parties, and we can only hope that's what proves to be the case in the Commission's attitude going forward. No doubt it would help if decisions are well documented and carefully considered. Thank you. Next slide, please. And very briefly, I wanted to highlight in talking about these issues, a third theme, which is that we're seeing a lot of boards approach us to ask about the role that their charities can play in relation to environmental action, and in particular in the response to very urgent concerns around climate change, where we've been told by authoritative sources, that we have a very short time in which to take action. I think it was the chair of the Intergovernmental Panel on Climate Change who warned us that there's a rapidly closing window to achieve a livable future. And in that context, we're seeing a number of organisations say, well, what can we do? And it's relatively easy for those that have environmental objects, and they are likely to have considered those issues carefully, but others are saying, how far can we go? We are aiming to pursue best practice operationally, internally, but can we do more? And I think all that we've just said about managing to consider carefully and document decisions on controversial issues applies in that scenario. Next slide, please. Another aspect of environmental action or response to environmental concerns that's attracted attention recently is the desire to invest ethically. That is, to pursue investments while taking into account factors other than financial return. And this was considered in the case of Butler Sloss and others recently, where the Ashton Trust and the Mark Leonard Trust sought guidance from the court on how far their boards could seek to avoid investments that conflicted with their charities' objects. So in those cases, they're two charities with general charitable objects, but with strategic focus on the environment and on the relief of poverty. And they were looking at the environment. They sought to put into place investment policies that meant that their investment managers would avoid investments that clashed with their pursuit of the conservation of the environment. In particular, would ensure that the overall portfolio was managed in a way that met the aims of the Paris Climate Agreement. So an agreement that doesn't apply to individuals, doesn't apply to charities, of course, but where they wanted to ensure as a charity with a focus on the environment, that their overall investments fell into line with that. And the guidance was sought because there's a feeling that the leading case in the area, the Bishop of Oxford case back in the 90s, 30 years ago now, had left some areas of uncertainty, in particular about the approach that trustees could take where there was a clash between the objects and the investments they wanted to pursue. And they sought guidance from the court to try and reduce that, because by imposing these investment policies, they were taking a very substantial step for the two charities, and one that could be described as momentous, in fact. Have the next slide, please. So three core elements that we want to highlight in relation to the decision. First is that trustees can choose not to make investments where they are directly contrary to their charity's objects. The second, that in doing that, there's a discretion. And this was the thing that wasn't entirely clear from the Bishop of Oxford case, where the question that was remaining was it mandatory? Was it the case that if an investment you wanted to make would involve a conflict with the objects, does that mean that you absolutely couldn't, as a board, make that investment? Or did the board have some discretion? And so it's found clearly that there was a discretion, that was triggered, the exercise of that discretion was triggered where the board held the reasonable view that an investment that was proposed might conflict with the objects, and that in exercising its discretion, trustees must consider the likelihood and seriousness both of the conflict itself, the conflict between the objects and the proposed investment, and the financial effect, with guidance from investment managers so that they were making that decision on a properly informed basis. Okay, next slide, please. The other case it's worth mentioning, because again, it's going to have an impact on charity governance moving forward and on some of the work that we can expect from the Commission, is the Children's Investment Fund Foundation. And this was the Supreme Court decision that looked at the duties of members of charitable companies. So the many charities that are established as companies largely limited by guarantee, and what duties the members had when they came to exercise their right to vote in making a decision, for example. And here it was found that those members have a fiduciary duty. They have to act in the best interest of the company and in pursuit of its charitable objects. And that confirmed a view that both the Commission and many others had held for some time. It does, however, bring a number of issues and a number of questions to the fore, including how exactly organisations will manage subsidiary duties. How will they manage the potential for conflicts of interest, for example, between the duties owed by members and other roles they may have. What will happen also where you've got a large organisation with a very large membership, how will there be that kind of reassurance about the way in which the duties of individuals are managed? So quite a range of decisions, and also how far will it be appropriate or desirable to modify the duties of members by making changes to the governing document. So lots of questions emerging from that, but the core decision is that the members of charitable companies are fiduciaries, and so they can't simply act in their own interest in making decisions. Next slide, please. And before moving on, I should just say that both in relation to the duties of the members of charitable companies and also in relation to investment decisions and ethical investment, we can expect further guidance from the Charity Commission. And if you'd like to know more about that, please do sign up for our Charities Law Brief, and we'll be updating people as and when those bits of guidance come out. So finally, and very quickly, I want to canter through 5 areas of development that we identified in relation to the Charity Commission's approach to inquiries. The first of those is prudence and commercial arrangements in particular, but duty to be accountable, trustee engagement, board diversity and turnover, and of course safeguarding. So if you can move to the first, please, next slide. So the issue here is about prudence, and the context is that there are a number of inquiry reports, including Kids Company report that many of you will be familiar with, and another report into the inquiry into the alternative animal sanctuary, in which the Charity Commission emphasises its view of what it was prudent for the board to do. And the challenge in that is that it appears that the Commission are seeking to develop, if you like, a position on this that goes beyond the strict legal position. So no legal advice to charity trustees about decision making tends to be complete without saying that provided everything else is done properly, the trustees have a discretion in the decisions they make for the charity, provided that their result is a decision that a reasonable board of trustees could make. And you'd hope the Commission wouldn't seek to substitute its view for that decision, and it doesn't normally do so. But in a number of inquiry reports, there appears to be evidence of the Commission making some inroads into this principle, perhaps simply through loose wording. And those 2 examples we'd highlight would be one in the case of the alternative animal charity I mentioned, where there's a look at a fundraising arrangement, and the Commission said it wasn't a sound decision for a charity to enter into a fundraising agreement based on the Commission's evaluation of the commercial terms of that agreement, and in particular the fact that 18% of funds raised would reach the charity in question, and that there were some practical and legal obstacles to exiting the arrangement. The challenge, of course, being that in principle, any commercial decision which doesn't eventually turn out as well as perhaps the trustees or the leaders responsible for negotiating it anticipated, could well be looked at in this way with hindsight, so that the Commission emerges to say, well, perhaps this wasn't a prudent decision to have entered into the first place. And then similarly, in relation to Kids Company, whereas the High Court provided welcome, robust and authoritative support of the trustees of Kids Company, as many of you will have seen. The Commission commented on that by reference to prudence, saying that the trustees' decision to put money into the charity's expansion rather than to build up reserves fell within the wide range of reasonable decisions the trustees could make in exercising their discretion. So you think that was all to the good. It was within the range of reasonable decisions the board could have made. However, in the view of the inquiry, the Commission, it would have been prudent for the charity to seek to build up reserves to provide it with a financial cushion in the event of unexpected expenses or an unexpected fall in income. That's perhaps not an unreasonable conclusion, but do we really want the Commission to be going beyond consideration of whether a decision made by the board was within the range of reasonable responses to comment further in difficult cases like that? So that's the first piece about prudence. Next slide, please. So this is accountability, and the issue here is simply that in a number of inquiry reports, the Commission appears to be moving from using the term accountability to refer to the bundle of different statutory reporting duties that trustees have, whether that's filing changes to the governing document with Companies House and the Commission, or filing the annual report and accounts, and going beyond that to seek some form of positive duty to demonstrate compliance, and even perhaps to demonstrate that in your organisation you have the right level of overview and an internal accountability in relation to delegation from the board to others. And the concern again is that that's quite a broad potential duty. It's not clear what it's rooted in, and some boards will be concerned that when they're being examined with the benefit of hindsight, it will be hard to respond to concerns raised around this issue. Next slide, please. So finally, if I bring the three final issues together, I think these are relatively well recognised and expected. The first being that there is a growth in concern about trustee engagement, and the theme comes up in several different ways. There's quite a lot of talk about internal accountability and about oversight from the board, and also quite a few references to collective responsibility. What we're seeing is increasing references to this idea of the requirement for collective responsibility and constructive challenge in terms that that do not make entirely clear the basis for the requirement imposed in retrospect by the Commission. The next is board diversity and the turnover of the board, refreshing the board. That's, I suspect, old news to most of you. We know that the Charity Governance Code has some really helpful recommendations in relation to board diversity, it is also turning up in inquiry reports again, unsurprisingly. And then finally, I won't say much about safeguarding, although there is, of course, little that's more important than taking steps to keep safe everyone who comes into contact with your charity. It clearly remains a Charity Commission regulatory priority, and we can expect the guidance on the issue to be continually refined and updated, and for the Commission to become involved if it has concerns about the safeguarding governance of a charity. So I think the final thing I want to say on that is that as the Commission has been refining its thinking, it's given a very clear and compelling kind of articulation of the importance of keeping people safe, saying safeguarding is a fundamental and integral part of operating as a charity for the public benefit and not simply an overhead to be minimised. So safeguarding, keeping people safe, is the fifth of those areas of forecast charity regulatory growth. Next slide, please. So just in summary, three things we've covered are the implementation of the Charities Act 2022, the way in which the Commission is developing its regulatory standards, and we touched on the new Commission chair and what might be a new approach, a new tone to the Commission's interaction with charities. And just got one or two final comments to make. So next slide, please. Just got the policy tracker is a tool that we've got through our VWV Plus arm, which enables organisations to share annual updates to key policies. to ensure that those policies can be used to support staff inductions and to distribute documents associated with policies, including health and safety documents. And we've got a poll on that for you.
Thank you, Shivaji. So I think we've got time to answer some questions, if that's okay. We've got a question here. To clarify, the new Act allows statutory charities to make ex gratia payments. Is there any other guidance which statutory charities should take into account? Shivaji, should I have a go at answering that?
Please.
The short answer is that what the new Act does is allow all charities, not just statutory charities, to make ex gratia payments on the basis I described, really, which is that there's a sort of sliding scale depending on the level of income. So for smaller charities, it was starting at £1,000, and for charities with annual income over £1 million, then you get up to a maximum amount of £20,000. So it does apply to all charities, not just those that are established by statute. In terms of guidance, I think the best place to go actually is there is some guidance on ex gratia payments from the Charity Commission, which I think is it's CC7, and I think it's quite a helpful explanation of what they regard as an ex gratia payment. And I guess the key point there is it's got to be a payment that there's no legal obligation to make and a pure moral obligation. So the trustees have to conclude that actually they don't think it's necessarily in the best interest of the charity to make the payment. They just feel that the payment ought to be made morally. So that guidance from memory is actually not particularly long, but quite helpful. So I hope that answers that question. There was also a question around which Shivaji might be one for you. Has the Butler Sloss case you mentioned been a major change in the law in that area?
That's an interesting question. I suppose my take is that the core is that it's provided a really useful reconsideration of the principles of the Bishop of Oxford case 30 years on. It's clarified elements of that decision and sets out really helpfully the steps that trustees should be taking when they're considering ethical investments. Do you want to add anything to that, Con?
Yeah, the only thing I think I'd add is that there's quite a helpful bit in the judgment from the judge, which makes it clear that this is all different from moral questions, if I can put it that way. I think what the judge said was that there's always room for differences of moral opinion about a particular case. This has got to come back to, I guess, fundamentally what's in the best interests of the charity, and that trustees' individual moral views are not strictly relevant. Probably time for just one more.
Do we have another question, Colin? If not, I wondered whether you wanted to make a couple of comments about meetings. That's an issue that isn't strictly on the agenda for today, but might be relevant.
Yeah, so perhaps just finish on that, and something we didn't cover in the slides, but well worth mentioning, I think, that you may already be aware, but the Charity Commission have withdrawn the liberalising approach that they announced in the context of the pandemic, where they said essentially we think it's fine for trustees and members of charities to have meetings online, even if your constitution may not provide for it. That has now been withdrawn. They're essentially saying if you want to have meetings online, you need to make sure that your constitution can provide for it. So just a practical point to bear in mind there. I think that we are pretty much up against time. I'm just going to check whether there are any further.
I think I can see one, Con, which is just a question about board turnover, and I think that's from Stella. And just to say, Stella, you're absolutely right. I didn't say a great deal about board turnover. I think the governance code is pretty good on recommendations there. So the idea of ensuring that there are terms of office and that there's a clear structure to how the board is refreshed, and in particular that if there's a decision to differ from the sort of model that comes through from the governance code of 3 terms of 3 years, that the board should be able to explain why. because although of course, there may be different things that are appropriate for particular charities. It may be that you're going to struggle to find as many trustees as you'd like. The board should at least have considered the issues sufficiently to be able to explain why. And that's only more important in the current time, where people will also be saying that your board hasn't changed for a while and perhaps it doesn't look as representative as it could.